Welcome to our informational series presented by motenanthelp.org and Missouri Legal Services. In this segment, we will discuss the discovery process in an eviction case in Missouri. When you're facing an eviction lawsuit, you may wish to do some investigation about the facts of your case, including gathering information from your landlord. This process is commonly called discovery. Discovery can be formal or informal. Informal discovery is the voluntary sharing of information without a formal written request. Informal discovery is faster and easier. However, because it's voluntary, either party may refuse to produce certain documents or information. Formal discovery is governed by the Missouri Rules of Civil Procedure, including important service requirements and deadlines. Commonly shared items include a copy of the lease, any ledger of what is owed, and any notices that either party sent the other. If you're unable to share such items informally, then formal discovery can be used to require a landlord to share withheld documents or information. The rules allow parties to issue 3 types of discovery requests to the opposing party. 1. Interrogatories, which are questions directed to the opposing party. 2. Requests for the production of documents, which allow you to seek relevant communications, photos, recordings, and other documents. And 3. Requests for admission, which require the opposing party to admit or deny certain facts related to your case. These are formal tools to obtain information directly related to the lawsuit at hand that might be helpful in gathering evidence for the trial. The discovery requests must be served to the opposing party, or their attorney if they are represented. You can serve the discovery requests by mailing or emailing them. You must also file a document called a certificate of service with the court that includes the date and method you used to serve the documents to your opponent. For questions about filing your certificate of service, you should visit the clerk's office in the court where your case will be heard. The rules allow 30 days from the date of service to respond. Make sure you have enough time to complete formal discovery before your trial date. Because eviction cases are expedited, there is often insufficient time to complete discovery pursuant to court rules. motenanthelp.org has DIY discovery documents if you need to request additional time to complete discovery before your trial date. Your opposing party will serve their discovery responses and documents to you and file a certificate of service of those responses with the court. Your opponent may object to some of your requests on the grounds that they did not comply with some aspect of the discovery rules. If you disagree, you should first try to resolve the dispute informally in writing. If the opposing party refuses to withdraw the objection, you can file a motion to compel, requesting that the court compel the opposing party to respond. The judge will determine whether the opposing party must respond. Your landlord can also serve you with the same types of discovery requests. You are obligated to provide them with your responses and objections within 30 days. Be especially careful with responding to any requests for admission. If you don't respond in time, your opponent can request that they be admitted for failure to timely respond. If you believe you may need to defend yourself in an eviction proceeding, you can find other helpful resources online at motenanthelp.org. By being informed, you can better navigate these legal processes and protect your rights. For more detailed information or legal advice, consider consulting an attorney. The information in this video is not legal advice.